Hi, everybody. Just letting you guys all get logged on. Hello. There's a bright light behind me that is blinding you. Let's see if I can make that go away. Or it's blinding me. Hi. I hope you guys can hear me. I got some stuff I want to talk to you about, and you're not going to like me very much today. Sorry. I'm not in
At
the
least
office.
you look pretty.
Oh, you like my new hair?
I do.
I'm not in the office today. There was too much traffic and bad drivers for me to make it into the office. So they said I could work from home today. And then guess what I found out? I'm teaching crime-free housing in Riverside this afternoon. So guess who has to drive to Riverside anyway? Oops. 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 I'm just letting people in here. So bear with me. Hello, everybody. Good afternoon. Happy Wednesday. We're just getting everybody logged on. And we'll go from there. I do have some stuff I want to talk to you guys about. You're not going to like what I have to say, but hey. And then I was hoping, let me see if she gets on. I saw Val got on. Hi, Val. Here comes Allie. I got news for you guys, but I want you to put the pieces of the puzzle together. Aaron's on. We're rocking and rolling. Just letting everybody get logged on, okay? Let everybody get going with us and get things started here. All right. So today, this morning, I got in my, we're still letting people on, sorry. We're still doing it. Happy Wednesday, everybody. I wonder, is it raining where you are? So went to start my day this morning. Traffic was atrocious from all the rain and the weather, and getting to work today for me just wasn't going to happen. So I am at home, and I thought I was going to get to play hooky all day. I was so excited that I was going to get to play hooky today. And hi, Victor. I was so excited, and I just realized something. I have to be in Riverside at the police department to teach their crime-free housing this afternoon. So as soon as we're done, I'm going to get in my car and drive to Riverside and make that happen. Oops. Blonde. Sorry. Oops. So I almost got to play hooky, but it didn't quite happen. Darn it. So I want to talk to you guys today about a couple things. Aaron, I know you're on here. The attorney is reviewing your contract today. I've come up with a plan of action, but I want them to approve before I talk to you. Okay, hope that makes sense. But I want to make sure legal counsel's on the same page we are before we strike. And just so you know, darling, it looks like we got every reason to strike. Okay. Okay, I'm excited for you. All right, excited. So just so you guys know, if you're dealing with a problem, a nightmare, you have that one issue that's just driving you crazy, and you reach out to me, I can try to help steer you in the right direction, point you in the right direction. That's exactly what I'm trying to do for Erin here. She has a material breach and a nuisance going on in one of her units, and it's in Larso. So it's like, wait, can I do something? Maybe I can't do something, but I am talking with the attorneys before we strike so that we don't make any decisions based on emotions. I think that's what I'm trying for there. So definitely have some things I want to talk to you guys about, and it's not good, but don't shoot the messenger, okay? Let me explain it to you like this. Currently, under current law, right now, the city of LA doesn't have any COVID restrictions at all. Want me to say that again? Currently, right now, right here in River City, there is no COVID restrictions in the city of Los Angeles. Sorry, my alarm went off. So tell me you're late. Go talk to your people. Okay. City of Los Angeles doesn't have any moratorium, anything right now. Actually, their new ordinance doesn't kick in until June 1st. Okay. That's for the city of LA. Their ordinance kicks in on June 1st. With that being said, I got a question for all of you. Okay. Wait, Arlene said something. Hold on. Let's see what Arlene said. Yesterday in an AGLA meeting, they talked about $9 a month liability insurance the tenant should have in addition to renter's insurance. Are you familiar with what they're talking about? AGLA has an insurance company they're working with that could offer additional services to landlords. And I know, but I'd be more than happy to do the research if you want me to. It doesn't take me long to ask the right questions, just saying. No problem. Now I lost my train of thought, Arlene. What was I telling you guys? Oh, city of Los Angeles. It's okay. I'm blonde, you guys. I'm blonde. It's okay. City of Los Angeles has no moratorium right now. The only thing protecting the people in the city of Los Angeles currently is the county's moratorium. Let me let more people in. Hang on. So if the only thing currently protecting the residents in the metropolis of the city of Los Angeles is the county's moratorium, do you honestly think they'll allow it to expire at the end of this month? Hear me out. Because if they do let the county's moratorium expire at the end of this month, do you know what that does? It makes it so we, the landlords, can attack the tenants for 60 days before the new ordinance comes in. What do you think we're going to do? Attack? You think? I got a feeling they're going to extend the county moratorium to protect the residents of the city. I don't know that as a fact. It just makes sense to me. And if you think about it long enough, it'll make sense to you. I don't think the powers that be are going to allow us, the landlords, to attack the residents of the city of LA. I think they're going to do something to offer additional protections to those people. There's no doubt in my mind. They are not setting us free, folks. There's no way. No way. I hope that makes sense to you, what I'm saying. We're all anticipating the county's moratorium to end on March 31st, the last day of this month. If in fact the county's moratorium ends on the last day of this month like it's supposed to, there's nothing protecting the residents of the city of Los Angeles until their ordinance kicks in on June 1st. So I got a feeling we're going to see something happen in the very near future. I don't think the powers that be will allow the residents of the city of Los Angeles to be exposed to us landlords without any protections. And if you think about it, I think you'd agree with what I'm saying. They've gone this far with all these protections. I don't think they're going to allow us to attack in the city of LA, especially with that new ordinance kicking in. So with that being said, just think about it. I don't know anything. I'm just thinking out loud here and I'm processing. So I haven't heard anything. There's nothing in the works. Okay. I'm just trying to give you guys a heads up of something to watch out for is I think they may extend the county moratorium just to protect the residents of the city of LA. But I don't know. And if they don't, I will be so excited. So excited. All right. So wanted to talk to you guys about that because it makes sense when you look at the big picture from a distance. I have no doubt if they extend the county moratorium, it's going to cause some problems with some of our landlords. Yeah, some of us are full-o-meter to here. Okay, we're done. Stick a fork in us. Yes, Erin. Erin is having her house held hostage against her. We all know what that feels like. It's happened to us from time to time. Unfortunately, hers is in the middle of the devil's cauldron, and it's at the fault of the tenant. So, hey. Larso, so if your suggestion is to serve notice for non-payment of rent of February and March, what happens if we just today received a COVID relief payment? Does that count towards current rent or to previous? That payment would cover 2 months of rent. In that payment from whomever gave it to you, they define where that money's to be applied. You must follow their instructions. So when some of the COVID laws first started coming out, they changed the way we did our accounting. And how it was written in there is it was changed until October 1st of 2025. And what it reads is rent must be applied in the month it was received in, and any overages go to future months, not towards the rears, unless the tenant puts in writing where that money's supposed to go. Most of these programs will send you a check and say this is for July's rent of 2022 and September's rent of 2021. I mean, I'm just giving you an example, but most of those checks define where the money goes. So read the details, okay? It's on the details of the actual check or the check stub. And the reason that they put it there is so that you can't misapply it. They're telling you right on the check what months it's for. And if they don't, you need to call and ask your tenant where they want it applied. And they have to put it in writing where they want it applied, okay? We don't get to pick where it goes. Because if we got to pick, we would put it on the most previous past due balance. Let's face it, that last one, way down there, okay? Hang on. Melanie, so that answers your question. Trey, when can we start providing notice for pass-through charges for retrofit? I'll let you know. Currently, there can be no additional expenses to the tenant at this time. And I'm telling you right now, that'll probably get extended until June. Am I obligated to give potential renters, okay, they're not potential renters, they're applicants, okay, applicants, an application in Spanish? No. Geraldo, I love you for asking this question. This is a good one, you guys. Bingo, bingo, bingo. This is a huge problem, and thank you for addressing it. Landlords, property managers, please pay attention. He has a great point. The very first time you deviate from the English language in your notices and all of any document, and it could be anything, Chinese, Japanese, Cantonese. I mean, it could be anything. Okay. I'm not trying to be rude by missing a language. Okay. I'm just trying to say, once you change and you change the dialect into there we go. That's the word I wanted, the dialect. When you change the dialect into a different language, you then are required by law going forward to complete every document in that dialect going forward. And I'm going to tell you guys something right now, so please pay attention. What language do they litigate things in courts in California? English. Only English, right? Your attorney most likely cannot read the documents that you have translated to understand if they were translated properly. See the problem? When you look at a notice and you know that it has to have specific verbiage, you know, all those legal terms and that jargon we don't understand, how in the hell are you going to understand that in another language? Courts are litigated in English. Once you send any kind of notice or documentation in another language, you then have to continue in that language. It causes a huge problem for you later if you get involved in litigation. So I would never supply an application in Spanish, because then I'd have to do every document thereafter in that language, including a 3-day notice. Have you guys ever seen a 3-day notice in Spanish? I have. God only knows if it has all the right verbiage. You know how they changed the law. You must pay the rent within 3 days, not counting weekends, holidays, judicial holidays. If you didn't speak the language that had to be translated in, how would you know if it was translated properly? Don't do it. It's a bad idea. I also don't want an issue with a rental agreement in Spanish. I will speak to the applicants and renters in English. Don't care how you speak to them. It's what you put in writing. Once you go Spanish, you can't go back. I love you, Val. That was funny. It's not just Spanish, though. Some people will send a bedbug notification to them in Cantonese or Thailand or whatever their language is. Okay? They don't understand that once you do that, every notice thereafter has to be in that dialect. Ugh. And then you guys want to send it to me. Hey, Patty, does this notice look okay? Hell if I know. Ask somebody else. I can help you. I think I need Rosetta Stone just so I can be a little bit more functional with my life. Okay. I do speak a couple languages. I speak sarcasm. Sorry. I do know some sign language, but nothing I could show you here. I'm playing. One of my good friends is hard of hearing, and she wears hearing aids to help assist her, but she signs. And anytime you like rub your nose or something, she looks at you. Are you talking to me? It's kind of funny. I tease her a lot about it. She teases me too. Uh-oh, Arlene's got news. What do we got? Friday. No, FYI. Sorry, new glasses, folks. FYI, 6 p.m. today, a Zoom meeting, LAHD renter protection meeting. And there's the meeting number, you guys. If you want to invite yourselves to the Zoom, that's how you do it. I'm going to screenshot that. I may swoop in and try to join that meeting myself. Thank you very much. You never know. Sometimes they'll answer a question for me. Not always, but you never know. So I talked to you guys about the county potentially extending, because I don't think they're going to leave the residents of the city exposed, is what that boils down to. I don't like the idea, but the reality is it might happen. So be ready for that. Also, I have some questions, but I have to talk to you guys about them because an attorney brought something to my attention and I need to be careful. Hang on, Jay, what do you got? So from now on, any rent paid can't be applied to the back rent or just the COVID back rent. It's not from now on. It happened, I want to say it happened in the first moratorium for COVID. So it happened in 2020. I could tell you that. I want to say it was the one where it first ended in September and then one started in October. It happened in that one. And what it reads is any funds being paid to the landlord must be applied in the month they were received. Any overages go to future months, and it only goes in the arrears if the tenant puts it in writing. Okay, so the tenant would have to put in writing, I want this much money credited to April of 2020, this much to May of 2020, this much. They have to tell you in writing where to apply it. It's bullshit. And I could tell you why they made this. Do you want to know? Because I'd be more than happy to spill my guts to you. It's to help protect the tenant, and I'll tell you why. We can only go back 12 months on a 3-day notice to pay rent or quit. We can't go back 12 months, more than 12 months, only 12 months on a 3-day notice. Pay attention. All the moratoriums ended a protected period and then gave them 1 year to pay the rent back for that period. Why would they do that? Because when that 1 year is over and that rent's due and payable, I can't evict them for it. I can only sue them in small claims court. I can't ask for that money on a 3-day notice. That's why they did it. When this ends and people have to be responsible for their rent, like in other counties, I'll tell you what they're doing. They're paying their current months of rent and maybe a little bit towards that past due balance, or nothing at all towards that past due balance. But they're paying their current rents so that we can't touch them. They're not stupid, folks. They're pretty smart. They have 1 year after the protected period ends to pay back the money they owed during the pandemic. That was done because we can't ask for that money on a 3-day notice. Understand? Hope this makes sense. This was built by design. Make no mistake. And now I'm going to speak to you out loud. Let me see what this says. Hang on. Hi, Val. I can see you. Yes, in Kern County, I have a cranky old vet tenant. I'm about to raise his rent. I have not kept up annual increases or raises, so he's getting a real steal. So a 10% increase is in order. I know he always cries poor, etc. Does the VA provide any assistance? Our vets get nothing, why others, well, you know. I understand. Tell him to contact the VASH program, VASH. It's the Veterans Assistance Supplemental Housing Program. It's the one program out there that's federally funded that this gal totally agrees with. Let me explain. It is Section 8. No ifs, ands, or buts about it. But in the beginning, it's called the VASH program. Okay. And what it is it works just like Section 8, but a lot of times the veteran, I almost said veterinarian, my bad. The veteran does not have to pay their portion. It's all paid by VASH. So it'd be like all being paid by Section 8. Okay. What I love about this program is they have social workers that help them sign up, and then they stay with them for the 2 years of the VASH program. What they do is they come out to the property quarterly and inspect it. They do, to make sure that their tenant is following the rules, keeping the house clean, notifying you of repairs. So now you have a worker that's going into the house 4 times a year and letting you know if there's any problems. Section 8 doesn't do that shit. I'm just saying. So the VASH program is great. After 2 years, it automatically rolls to Section 8, and then they have a Section 8 worker. Okay. I have had nothing but good with this program. I realize that there's a bad apple in every program, but with that particular VASH program, I haven't had any issues yet. It's to help our veterans, it's veterans assistance, and I'm all about helping the people that help make our country free. Okay. And I know that that's questionable at this point, but it wasn't when they were fighting and losing people standing right next to them. I'm all for our veterans. Okay, let me talk to you guys about something. And I have to be careful how I present this because it could be considered legal advice. I am not giving you legal advice. I am not an attorney. I want you to, hold on, let me put my phone down. Instead of looking this way like tunnel vision, I want you to broaden your horizons. I want you to see on the outside edge of the box, okay? Listen to me and hear me, please. January 1st, 2017, the eviction masking law was passed. What it says is tenants that go through an eviction process will have their records sealed, and no one will ever be able to see if they were been evicted before if the landlord doesn't prevail within the first 60 days of the case filing. So let's say this in English. So what that means is the tenant that moves out in the middle of the night scared because you served them with a lawsuit, they have an eviction on their credit. And the person that it took almost a year to get them out and they raked you over the coals and asked for a trial by jury and it cost you $8,000, their record's sealed and nobody's going to see that they've been evicted. Now fast forward to where we are today and let's have a conversation, okay? Listen to me, please. If I can't see an eviction on the credit report, but I can see some evictions, those ones I can see means the tenant moved out in the middle of the night and ran scared, right? That's the tenant I want. I don't know about the rest of you, but at this point, I want what I can see, and I'm scared shitless on the stuff I can't. I never, ever thought in 30 years that I would consider advertising evictions welcome. Please inquire within. I am considering switching sides of the fence here. When all the rules are against us, we can't see that they've been evicted. We can't see that they asked for a jury trial, but we can see this other person has an eviction on their credit, which means they moved in 60 days of the case being filed. What am I afraid of? What I can see or what I can't? I'm not trying to tell you guys what to do. I'm trying to get you guys to think. We have been told for 30 years in my career, we don't rent to people with evictions. Evictions are a big no-no. We can't see them anymore, folks. And what we can see means they ran. They got scared. I got my house back in 60 days. Are you listening yet? Are you paying attention? I don't want you to do anything. I just want you to think a little differently. Okay? I'm trying to get you from doing tunnel vision to opening your blinders, because I'll tell you, I'm starting to open in mine. I want that guy that moved out in 60 days. That's who I want as a tenant. I will chase him down. Evictions welcome. I'm scared about what I can't see. And I'm going to keep talking about this. I'm actually going to talk about this today with corporate America and see what their thoughts are on it. But starting September 1st, the playing field is changing. We're losing more teeth. Gavin Newsom made a new law back in October regarding creditor and debtor, okay, in the state. And what that law says is you cannot, as a creditor, put a wage garnishment against a debtor in the state of California starting September 1st, unless they make more than $41 an hour. I don't know about you guys, but for most of the residents in the state of California that are making $41 an hour or more are homeowners and not tenants. Wait, Patty, what did you just say? You said that we can't get a wage garnishment against a tenant unless they make more than $41 an hour? That starts September 1st this year. Yes, that is what I'm saying. New law. Well, they took away our recourse. We're going to be quicker to start an eviction and we're not going to work with tenants anymore. Isn't this the exact opposite of what the government wants? You know how we wait 2 or 3 months before we start the eviction against our tenant because we really don't want to evict them and we want them to make this right? Are we going to do that anymore if there's no recourse for us? Or are we going to serve a 3-day notice on the 2nd of the month, start eviction by the 5th? We'll see. They're taking away our tools. It makes it more difficult for us. If we don't change with it, we're going to get steamrolled. I never ever thought in a million years that I would hear myself say, evictions, welcome, inquire within. I've been all about the total opposite of that my entire career. Yeah, we're going to have to go back to the drawing board. We're going to have to do some serious thinking outside of the box here so that we can continue to function and be profitable in our businesses. Okay, enough with Debbie Downer talk. I just am trying to make you guys understand what's coming potentially at us so that we can brace for impact. I don't like to be blindsided. I like to know what storm is in on the horizon in the weather. I want to see what's coming at me. Yes, Jay, I'd be more than happy to go over the eviction masking law. Mind you guys, this is called the eviction masking law. It passed January 1st of 2017. And what it says is if the landlord prevails, meaning they win the case within 60 days of the case filing. So from the filing date to 60 days later, judgment entered in favor of the landlord. So from the day it gets filed, so this is during the answer period while your tenant has time to file an answer, and we need to get the judgment entered. That default judgment, that's what needs to be entered. If that happens within 60 days of case filing, then more than likely the tenant will have an eviction on their credit. If it goes over 60 days, the record is masked, it's sealed, and no one can see that there's been an eviction. So what does that mean for you and me? It means when you run a credit report and you can't see an eviction on there, they could have an eviction that you just can't see. They could have asked for a trial by jury. They could have cost their landlord $10,000 or more. They could have asked, we can't see it. We don't know. My theory is this: if you look at the credit report and there's no evictions on there, chances are they've been evicted. That needs to be your mentality because you can't see it. Someone's trying to call me. Sorry, somebody's trying to call me in the middle of the Zoom meeting. I hate it when that happens. I apologize. Squirrel. Okay, so with that being said, you guys understand that the eviction isn't going to show if you're going to look at it this way. Bang, 45 days go by, we finally get a case number and the tenant gets served. Now you got 60 days. Are they going to file? Are they going to file a motion to quash? Are they going to file an answer? Are they going to do nothing at all? Even if they do nothing at all, unfortunately, to go through our court system right now takes longer than 60 days. You and I both know it. If their answer period goes by, there's about 20 days. Let's just talk out loud. Now I got 40 days before this goes under, and it's taking 45 days for judgment to get entered. Sorry. And it's taking 45 days for judgment to get entered. So the chances of their record being sealed is going to be very high at this point. That's what I'm trying to tell you. We can't see that they've been evicted. So just assume everybody has, right? We can't see that they haven't. But wait a minute. The ones that we can see, the people that show an eviction on their credit, that means the landlord won. within the first 60 days of the case being filed. That means either judgment was entered and landlord prevailed, or the tenant moved out in the middle of the night. That's a tenant I want. That one. Yeah, that one. I don't want what I can't see. What do they say? Fight the demons you can see, not the ones you can't. I don't know. I just want you guys to think differently when it comes to evictions going forward, because they are changing the playing field for us. They are changing the rules mid-game. Okay? We have to be more attentive to what's going on so that it doesn't steamroll us. I got to put my glasses back on. Melanie wrote something. Okay.
Hey, Patty, I have a quick question.
Sure.
So this is for an apartment complex with shared walls. The rooms are back to back. One tenant stays up all night and plays his video games and yells at the screen. The other tenant is saying that he cannot sleep.
Mm-hmm.
Is there anything we can do, or do we just tell him to suck it up, Buttercup?
It's not his own roommate, correct?
No, it's a shared wall. It's a unit 3 and unit 4.
Okay. Unfortunately, there is an abundance of noise coming from your unit between the quiet hours within our city, which are blank through blank. Please take note that you will be served with a 3-day curable breach of covenant for right of quiet enjoyment if this behavior continues.
And will you have an appointment to come look at the apartment?
Cliff, unmute yourself or mute yourself, please. Or I'm going to figure out how to do it. I just heard his voice is how I knew who it was.
The little dog along with the person.
I muted him. Sorry. It's the little things in life that make me happy. Sorry. I'm going to lose it. Somebody please ask me something or change the subject. Because that was way too easy. I wish I had that. I wish I had that when you were like talking to somebody and you could just go mute. I'm sorry. Welcome to meeting a blonde squirrel. You're right, Val, that was what I was thinking. Allie, thank you. Repeat the wording. Thank you. Get me back on track, you guys. I love all of you for this. Thank you. Repeat the wording. The wording is, unfortunately, it's been brought to our attention that you are disrupting the right to quiet enjoyment. And the city's noise ordinance is between the hours of blank and blank. In other words, go look it up from your city. Each one of them is different. Do not make up your own rule here. This will bite you. Got it? Go by the city's rule. If their noise hours are from 8 a.m. to 10 p.m., then that's what you go with. Got it? Otherwise, your right to quiet enjoyment statement doesn't work. So don't make up your own rules here. Okay? All right, perfect. You guys, and thank you for reeling me back in from the muting. It would be so wonderful if we could do that in person, to people. That was what I was thinking. Hey. All right. I know I need to get down to Riverside soon. Anybody have anything else for me? Everybody on the same page, reading the same book. I think it's Assembly Bill 12. That's still up for vote, you guys. They still may try to take away our ability to ask for a higher security deposit than 1 month's rent. So as nicely as I could say this, if you have a vacant unit and you're currently renting, fill up your buckets while the grunion are running. They don't run forever. In other words, if they're going to take that away from us in the near future, at least we can I was going to say capitalize, but that sounded so bad. At least we could protect our asset to the best of our ability right now before it's implemented. So if you have the opportunity to take a higher security deposit, do it.
Hey, Patty, I have one more thing to add on to the noise complaint
Yes.
that I just found out. The
Yes.
tenant who is loud
Uh-huh.
also has a disability.
Don't care.
Doesn't matter. Okay.
Look at it this way, okay? And I'm going to put it in a different frame of mind, and I hope it reels all you guys in, okay? Had a landlord in a property once, an apartment community, same kind of concept, units, shared walls. Tenant in possession of one of the units screamed all night long, like screamed, bloody murder all night long. She had PTSD. She was a veteran. She didn't sleep well. She was affecting the right to quiet enjoyment for neighboring residents. And if the landlord didn't do something about it, the entire community would have filed a class action lawsuit and sued him. So remember me, I'm all about our veterans, okay? I suggested that he paid to move them into a house where they weren't sharing common area walls so that her disability wouldn't affect others. It worked. Okay. Everybody was happy. She got moved into a house. Landlord paid first month's rent, security deposit. He paid the first 3 months rent and security deposit. Last I heard, she was happy at the house. Everything was great because there's no neighbors. Nobody cared that she screamed all night. So with that being said, I don't care if they're disabled. They can't disrupt everybody else in the building just because they're disabled. No. Makes sense? If the video man doesn't stop the noise, she can evict him with all of his non-evict business. Val, she can evict him anyway. That property's in San Bernardino County. So she can evict him for the disruption of right to quiet enjoyment and affecting neighboring residents. Teresa, how much can we raise rent for City of LA, not under rent control, built in 2003, hasn't raised rent since 2017, 10%? I'm not sure. I want to say you're most likely going to be at that 10%, but I want to double check. And you're going to have to bear with me because I'm going to Google it. One last question. The LARSO ordinance for June 1st, I can't find a copy of the ordinance. Okay. Right now, LA City isn't under any moratorium or anything like that. So what the city did, because they can't keep initiating a temporary law, is they wrote an ordinance that takes effect on June 1st, stating that you can't do evictions, and it's probably not about COVID is why you can't find it. Saying that you can't do evictions for unauthorized pets or unauthorized occupants until February. There's all kinds of rules in it. I'll find it, Melanie, and I'll put it up on here next week so you guys can look at it. Remember, it's an ordinance. It's not, and it's supposed to take effect June 1st. So I'll look it up and find it for you, I promise. Teresa, if rental agreement is monthly, renter since, wait a minute, Teresa, I don't know what you're asking me. If rental agreement is monthly and the renter since more than 5 years, Teresa, I think I know what you're asking me, and I'm going to answer it. Okay. And if I'm right, I want I want a gold star, a big gold one. Okay. No, I like silver better than gold, just for the record. I think what you're asking me is if the tenants live there more than 5 years, how much can you raise the rent if they're on a month to month? I think that's what you're asking me. Am I right? You can unmute yourself or you can type away, whatever you prefer.
Sorry. What did you say again? I'm sorry. You said what?
You wrote, if rental agreement is monthly, renter since M then 5 years. I don't know.
That we're raising the rent. I haven't raised it.
Okay.
And they've been there more than 5 years. Sorry, my shorthand is bad.
Rent, it's okay. I thought I figured it out, but I just wanted to verify. So let me explain to you. Doesn't matter how long your tenant lives there. That has nothing to do with how much you're raising the rent. Okay. What it has to do with is what kind of notice you use. Okay. If they are on Section 8 or you are doing an increase of more than 10%, there is no more 60-day notice. It's gone. They removed it. It's now a 90-day if you do over 10% or the tenant is on Section 8, okay? Or federally funded.
So that does not apply. So
anything 10% or less goes on a 30-day notice.
30-day. Oh.
Okay. Now, what you guys all need to watch out for is as these moratoriums are ending and as these things are going away, all of the little municipalities, you know, the cities in the middle are coming up with their own bureaucracy and bullshit. So pay attention. City of Pasadena has Measure H. City of Inglewood just initiated their own form of rent control at a different cap amount. All these little cities are coming up with their own bullshit, okay? City of Inglewood, you have to register your unit, just like in Larso. You have to be registered there. They capped the increase amount at a lower amount. They're coming up with their own rules, you guys. You have to check each individual city. Like I had some questions last night about Sherman Oaks. I know damn well that Larso swooped them up. So you may be governed by them now on what you can and can't do. If you are in LA County, please check your city for if they've implemented any kind of controls, because we are seeing that across the board. So be careful, okay? Be very careful. All right, you guys, if nobody else has anything, I'm going to end for today so I can get on the road. I have quite the jaunt in front of me. I'm going to talk to these professional property managers about 2 things. This extension, and I'm going to talk to them about how they feel about us losing all our recourse and not being able to garnish wages starting September. I mean, come on, we lost. What can we do to them? Nothing. Get them out. That's all we can do. Hi, Hilda. I heard City of Inglewood may be eminent domaining some properties to make room for incoming light rail to new stadium. Yeah, we're going to see some eminent domain coming off because they're implementing a train between Victorville and like Rancho Cucamonga here in the very rapid fashion as well. So a bullet down the hill train kind of thing. Saw something about that as well. So I'm sure we'll see some eminent domain stuff going off. Get ready. They're going to keep building us up like a metropolis. But we'll see what happens. Yeah, I have no doubt they'll do something like that in Inglewood. Right down Century Boulevard would be my guess. I hope. Come on, please, eminent domain my property, please. Sorry, a girl can dream, can't she? You guys have a great week. I will see you next week. Please think about what we talked about today. I'm not telling you what to do. I'm just telling you to open your blinders a bit and pay attention to what changes are happening. You guys have a great weekend. If you need me, you know how to hunt me down. Bye.